All right. Good morning, council, and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding over the cases we have here today. We have one case set at 9 o'clock this morning. That's Frazier versus Panera Bread. Want to introduce the other members of the panel today. We have Judge Harvey J. from Duval County and Judge John Harris from Brevard County. Just ask when you're making your presentations or we're not making your presentation, please keep your mic on mute and also make sure that we silence any noise making devices. I will do that on mine as well. And I'm going to assume that unless you tell me otherwise, I will assume that the appellant wants 5 minutes of rebuttal, Mr. Haskins. So speak into that if you want a different time for your rebuttal. And other than that, I will just turn it over to the appellant. Mr. Haskins, you may proceed.
Thank you. May it please the court. I am Steve Haskins, and I represent the appellant, who was the plaintiff in the trial court, Sharissa Frazier. And Judge, I would like to reserve the 5 minutes for rebuttal, if I may. In light of all of the evidence that was before the trial judge on this motion for summary judgment, I believe that all of those facts looked at together and considered all together could very well lead a reasonable jury to return a verdict in favor of the plaintiff, who was the non-moving party.
Mr. Haskins, can I ask you a question?
Yes, sir.
For the fact that this sign base, there was no sign attached to it. If there had been a sign attached to it, would you agree, different case, and arguably there would be notice that there's something on the ground that your client should have negotiated around? Is that kind of the unique fact in this case?
I believe you're correct, Judge. I think if there was a sign in the manner it was supposed to be situated, then that would be in the line of vision of somebody such as plaintiff, who was stepping up off the curb, turning to her left to head to the restaurant front door. And that, according to the photos we have seen, I'd have to say that would be in the line of sight. And if that's in the line of sight, then certainly by the ways of Mother Nature, something must be holding that thing up. So yeah, I would agree with Your Honor on that would be a different case.
And there's a photo that's at the record on page 148 that shows what I believe to be the base of that sign. Was the testimony that your client entered and stepped onto the sidewalk from which direction with regard or in relation to the photo and the base that we see?
Yeah, I think you have to look, Judge, at the photo that's in the record at 148 with the photo that was in the record at 142. The one photo on 148 is relatively up close. If you want to get a better bird's eye view of what happened, of the layout, which I think is important in this case, 142 is a photo taken from the back, looking at the restaurant building in the area where the plaintiff, her husband, parked, which was right next to this mulch bed or vegetation area. And if you could see in that, where she gets out of her passenger side, steps up on the curb, and once again, looking at 142, to get into the restaurant, one would have to turn left and head in that direction, which she did, which would take her right in front of the hood of her car. And so if you look then, tie that in with 145 or 148, I'm sorry. Yeah, that base is on the sidewalk in that photo in front of a parking stall where the plaintiff and her husband had parked.
Is there any photograph, Mr. Haskins, that shows what that would look like with that car actually in that parking spot?
Judge, if you look at the photos, that the 6 photos showing the sign base with and without a sign, there's obviously there's no car in those pictures. However, once again, if you look at 142, and that was clearly a photo taken at a different time, but it shows a different car that was parked in the stall where the plaintiff and her husband were parked at the time. And that kind of gives an idea, Judge, of, I guess, where the car would be parked relative to the sidewalk, relative to the entrance, and relative to where the sign base is or was.
Does it show, for example, if a car is parked there, whether the hood of that car, the front of the car covers up the base at any point?
Judge, there is no photo showing that. The only thing that I would point out to, though, and this was recited on several times in the appellee's brief, that the base was inches away from where the curb meets where the curve meets the sidewalk, which common sense would seem to be place it at a position where if you're parked in that stall, chances of seeing that or having it blocked from your point of view as you come up along the side of the car and step up onto that sidewalk, that would seem to lead one to conclude that, once again, this is not something that was in the line of sight. And that's the best we've got to go on that, Judge.
Mr. Haskins,
Yes, sir.
I understand that there are 2 duties, independent duties of a landowner occupier, and I think everyone agrees with this. One is to give warnings of any concealed perils that are known or should have been known by the owner or occupier, and then 2, to maintain the premises in a reasonably safe condition. Here, even assuming this was open and obvious, that would only take care of the warning side of the duty. There would still be an obligation to maintain the premises in a reasonably safe condition. You would agree with that, would you not?
I would agree with that, Judge. That's a separate, distinct, and independent duty. And the case law that has come out over the years has basically said, okay, if it was open and obvious, the landowner or possessor still has that duty to maintain, and the open and obviousness of the condition would go to the comparative negligence of the plaintiff as opposed to barring liability. But to your question, Judge, yeah, that's a separate duty that still exists, despite if it's open and obvious. And I don't think that ever got to the trial judge, that issue. I think the trial judge said, hey, this is open and obvious. It's not a concealed peril. And I think the trial judge ended the inquiry at that point and granted summary judgment without considering the concomitant duty to maintain in a reasonably safe condition.
And I don't disagree with what you just said, Mr. Haskins. I went back through this morning and read the court's order. It does look like the court found that your client's negligence was the sole cause of this accident. I assume, I think I know the answer to this before I ask, but I assume it's your client's position that causation, proximate cause, would be a jury issue in this case.
Yes, sir. I do.
And you mentioned comparative. I know sometimes lawyers, judges conflate comparative with causation. As I understand those concepts, comparative is separate and distinct from causation. And here it looks to me, based on the court's order, that the court found as a matter of law sole cause. So it would be your client's position that there was a jury question on proximate cause in this case.
Yeah, yes, sir. That also would be an issue that I believe should go to the trier of fact, the jury, and should not have been disposed of by this summary judgment order. But once again, the issues that came up was the open and obvious issue, which we all know under the case law, all of the facts and circumstances need to be looked at, examined, and to determine whether it was open and obvious. And even if it was open and obvious, the issue should this Panera have anticipated or foreseen that this base without a sign could pose a danger to its customers coming up out of the parking lot onto the sidewalk and encountering this base. As I pointed out in my brief, apparently the restaurant, when my client went in, she was told that one of the employees had removed the sign and had not yet gone out and got the base. I think one could reasonably infer that, you know, they were going to fetch the base and bring it back inside for a good reason. Also they're the ones, Panera is the one that placed this base in the position and location it was placed. So any issue of superior knowledge, whether any question of superior knowledge would have to fall on Panera, since they're the ones that put it there. They're the ones that admittedly was going to go out and get it and not leave it out there. Once again, I think, yes.
So I understand it. Again, I'm looking at the order on motion for summary judgment, and paragraph 23 says that your client's knowledge to any danger would be superior to that of the defendant and negate any duty which might exist. That's what you're dealing with now, correct?
Yes, sir. Yes.
And so your client's position is it would be nonsensical to say that her knowledge was superior to Panera's knowledge in this case.
Yes, sir. Yeah, I just think because of what I just recited to the court, their Panera's placement and their intent in going out and get it clearly places superior knowledge on their part, and not by this lady who I believe the testimony's gone to this restaurant. It was the first time, and not knowing there was a base sitting out in front of the car where her husband parked. So once again, judges, I believe that there's ample evidence to show genuine issues of material fact on these matters that I've discussed, and also to get to this duty to maintain and whether or not Panera breached its duty to maintain in permitting, because they're the ones that permitted this condition to exist in the place and at the time that it was. So without trying to repeat myself, I do believe, as urged in my briefs, that genuine issues of material fact exist, And the plaintiff would respectfully request that the court reverse this summary judgment, vacate it, and send it back so that a jury can consider all of these issues and arrive at a decision that I think should be in their hands in this particular case, and under all these particular facts and circumstances. Unless your honors have any further questions from me, I'll sit down at this point.
All right, thank you, Mr. Haskins. Mr. Ryder, you may proceed.
Thank you. Good morning. May it please the court, Jack Ryder on behalf of Panera Bread. Your honors, I'd like to start just by emphasizing and reiterating the current summary judgment standard. And I think it's critical to examine this case in the context of our current standard, which makes clear that the mere scintilla of evidence supporting a non-moving party's position is no longer sufficient, and the existence of any competent evidence creating an issue of fact, however credible, incredible, substantial, trivial, is no longer enough. And the reason I highlight that first and foremost, your honors, is because all the cases and the argument cited by the appellant, respectfully, I believe, were really resolved under the former standard. And when we examine the summary judgment in this case under the appropriate current standard, I believe it is clear that the undisputed material facts demonstrate that this was, number one, an open and obvious condition, and number two, was not unreasonably dangerous. And I'm going to talk about both of those factors.
Ryder, let me stop you there if I may. I'm going to the order of the court. You would agree that the duties haven't changed with the summary judgment standard, correct? I mean, the duties that a landowner and occupier still owes to an invitee are the same they've always been. You would agree with that, would you not?
I do agree with that.
Where in this order does the court deal with the first duty? Use reasonable care in maintaining the premises in a reasonably safe condition.
Well, your honor, so the court's order seems to focus more directly on the context of open and obvious. And I want to address that in two ways. I'll start, of course, by noting that, as the court is certainly well aware, this is de novo review. So to the extent that the trial court may not have been as specific on that particular issue, I think it's important to, of course, realize that this court, as the appellant and the court knows, can affirm for any reason if supported by the record in its entirety. In paragraphs 20 of the order, the court does talk about talks about wheel stop cases and describes them in the context of no unreasonable risk of harm. But what I wanted to also emphasize, your honor, and I agree, there are two duties. One is to maintain the property in a reasonably safe condition, and the other is to warn of latent or concealed dangers. And generally speaking, those are two duties in the sense that the open and obvious nature of a hazard may discharge a duty to warn, but it will not discharge the duty of a landowner to maintain the property in a reasonably safe condition. I completely agree. But there are cases out of this court, your honor, and there's many cases that have found that certain conditions are so obvious, so glaringly clear and obvious, so as not to be deemed to be inherently dangerous and cannot give rise to liability. So I do agree that there are two separate duties. And I believe that the trial court, while the focus was more on the open and obvious nature of this obstacle, I believe the trial court did address both by the references to wheel stops and the notion of whether or not they are create or present an unreasonable risk of harm. But again, from a de novo perspective, as this court examines whether or not the undisputed material facts here under the current summary judgment standard, recognizing, your honor, as your Judge Jay, as you pointed out, the duties remain the same. I believe that this court can and should affirm on both grounds, because this is one of those cases where this obstacle, this base presents something that is so glaringly open and obvious that it encompasses the notion of unreasonably dangerous. And we have cited, for example, your honor, in the case of Taylor versus Universal City Property Management, a case out of this court, there was a plaintiff who was not looking where she was going, just like the plaintiff admitted in this case, and fell on a planter. And this court concluded that some injury causing conditions are so open and obvious that they can be held as a matter of law, not to give rise to a dangerous condition. This court in Taylor referred to the photographs that were in evidence in that case, just like this court has the photographs here. And the court noted that the obstacle in that case, this planter, was, quote, glaringly open and obvious obstacle for anyone walking either on the walkway or the street, unquote, and concluded that because it was glaringly open and obvious, that addressed the inherent danger or the unreasonably dangerous component of the landowner's duty to an invitee.
Let me ask you though, Mr. Ryder, in paragraph 22, which I referenced during Mr. Haskins' argument, the second sentence says the record evidence is clear that the sign base was an open and obvious condition, and the sole cause of the plaintiff's trip and fall was her failure to address and avoid an open and obvious condition. So it seems to this judge that the predicate for the court's decision was based on causation as to whether in fact she was entitled to recover in this case. That's what that sentence says to me. Would you not agree?
I agree that the trial judge looked at this from the perspective of causation. I do, but I also believe that the judge got to that point by making the decision that this was an open and obvious obstacle. And because it was open and obvious, and so open and obvious, it made it not unreasonably dangerous as a matter of law. This court, of course, is free to completely disregard certain elements of the trial court's analysis if the court disagrees. But I do believe that the trial judge, in reaching the conclusion about the causation issue, if we read that one paragraph in the context of the entirety of the order, which is a lengthy, very articulated, well-reasoned order, I do believe the trial judge only got there after first reaching the conclusion that when one looks at the undisputed material facts here, particularly under the current summary judgment standard, it is an open and obvious obstacle. This was not something that was hidden in the shadows, or there was no inconsistency in the color between the base and the sidewalk. And as this court,
Mr. Ryder, do you have a case where the open and obvious condition, I mean, the planter was fixed, the curbs are fixed, the wheel stop is fixed. This is by its nature portable. In fact, was about to be moved. What case do you have where an open and obvious condition was portable as the wheelbase or the sign base was in this case?
Your Honor, the cases that I've cited are primarily fixed objects. They are, or they're uneven floors. I mean, there are so many different types of cases out there, but they all rest. I mean, let me say this: they don't, in my opinion, I don't believe that they hinge their decision making on whether or not the condition was a permanent condition versus a non-permanent condition. Rather, they talk about whether or not the condition is common, a common occurrence. Why that's important, Your Honor, and I believe respectfully, is that the plaintiff acknowledged that these sign bases, the idea of obstacles, the idea of something on a sidewalk like this is a common event. Now,
is it common to have a wheelbase with no sign in it? A sign base with no sign? That's not very common, is it? I've never seen that.
I think, Your Honor, that the sign and the base do raise at least some discussion point, but I don't think that creates a significant enough distinction here to turn this into a concealed peril. And when we talk, and the reason why I think this is important too, Your Honor, is when we talk about whether the sign was on the base, that goes to the issue of whether this was open and obvious. It does not, I do not believe, go to the issue of whether or not this was unreasonably dangerous, because according to counsel's argument, the appellant's position, had the sign been there, it would have been in the line of sight of the plaintiff, and then it would have been more readily visible. But we deal, Your Honor, with curbs, uneven pavement, walking from an elevated path to a lower path, dimly lit rooms with uneven floors. And in each one of these cases, which we have cited throughout our briefs, courts have found that these are not unreasonably dangerous, and they are. And the fact is that they were open and obvious to somebody who was utilizing their senses.
Mr. Ryder, if
take away
that's
from the testimony that the Panera employee was about to remove that base, does that add to the foreseeability of dangerous condition?
I don't think that that addresses or that implicates the condition here being unreasonably dangerous, Your Honor, because it doesn't change the fact that this was an open and obvious obstacle.
Then why was it even necessary for the Panera employee to go out and remove the base?
That is not in the record. I don't believe that there's specific testimony. I would assume that that was just part of the daily process. As the store was closing, they were removing the sign, removing the base, and the sign came out before the base. And it was just circumstances that as the plaintiff happened upon the curb, instead of walking directly to the store, she walked in front of her vehicle. And but I don't think
Isn't
that
the logical inference from that is that if you don't remove the base after you've removed the sign, then someone's going to trip over it, whether it's during business hours or not business hours.
I don't know that I would agree, Your Honor, that that's a logical inference under the circumstances. And here's why. First of all, the fact is that the base was not in a walking path. It was on a sidewalk. It was. But when I say a walking path, the base was, as the photograph displays, was centered in between the lines of where the vehicle would park. So when one vehicle, and unfortunately we don't have that picture that shows the vehicle there, but as one can see, because the base is centered, a passenger or a driver would get out of their vehicle and walk directly to Panera. And the idea of walking directly in front of the vehicle is not an expected pathway for a person who's exiting their vehicle and entering the store. And I still go back to the fact that when we look at the facts, in the overall facts here, things that we have in this record are that it was a clear sunny day, that there was enough space between the base and the curb to safely navigate and negotiate. And I think most importantly here, the plaintiff admitted that had she looked down, had she been paying attention, that she would have seen the base. I use the words paying attention, but she stated, question, do you think that if you had looked down a second time, you would have noticed the base on the sidewalk? Answer, if I would have looked down, yes. And that's the record at 86. This is not a circumstance where this was a hidden or obscured or concealed peril, such as a gap between a sidewalk and a tile. This was an open, obvious.
Yes. And that brings me to paragraph 23, and I asked Mr. Haskins about this. The court finds, based upon the record, that the plaintiff had the ability to have a firsthand view of the weighted sign base, and her knowledge to any danger would be superior to that of the defendant and negate any duty which might exist. I understand your argument, but how could her knowledge to any danger ever be superior to Panera's knowledge of this? I mean, I use the word nonsensical. That just makes no sense to me. How could her knowledge be superior to Panera when the employee is the one that placed this there, removed the sign from the base, and was in the process of going back and pulling the base? I just don't know how her knowledge could be greater than Panera's here.
I'll explain, Your Honor. Respectfully, Your Honor, it's a difference between the knowledge of the existence of the obstacle and the knowledge of the danger posed by the obstacle. Panera Bread would have had greater knowledge of the fact that the obstacle was there because the employee had removed the sign and left the obstacle. But the plaintiff had at least equal to, if not better knowledge of the danger that would have been posed by the obstacle, because it was the plaintiff who, using her senses, should have appreciated the existence of the risk, which was open and obvious, and walked around it or walked on a straight path to Panera. So it's not the knowledge of the obstacle, it's the knowledge of the hazard posed by the obstacle that the plaintiff had, I would submit, equal to or better knowledge.
Mr. Ryder, I was going to ask you a similar question. What Judge Jay just asked you, he used the word nonsensical. I mean, I find it borderline offensive that you would say she had, and you do say, you argue she had better knowledge of the sign base than Panera. That's simply not true. It can't be. She had better knowledge of the danger it posed. Well, if she had looked down and if she had seen the base, perhaps she would have equal knowledge, but she didn't. So how do you say that she had more knowledge of the danger? Not that she should have had more knowledge, but you say she did have better knowledge of the danger than Panera's. Panera was going out to remove it.
I understand what your honor's point, and I agree that if the plaintiff fails to utilize her senses to appreciate the existence of the obstacle, then yes, Panera Bread would have greater knowledge of the existence of a potential obstacle that could create a hazard. And I do believe that's what the trial judge intended when they reached that conclusion in this order. But I acknowledge that as it pertains to the base itself, that Panera had greater knowledge of the fact that the base was left there. If the brief suggests otherwise, then that was an error, because the point isn't the existence of the base itself, but the existence of a hazard posed by an obstacle that is otherwise open and obvious.
But how, back to what Judge Harris just asked you, Mr. Ryder, if she doesn't know it's there, had never been to this Panera before, how could her knowledge even approach the knowledge of Panera related to this base? Candidly, I just don't understand how that argument can even be advanced.
Well, the first thing I would say, Your Honor, is that, as I've said, this trial court order can be disregarded if there are components of it that the court finds are inaccurate. And I would suggest that whether or not she had greater knowledge or less knowledge, it's quite honestly not dispositive of the question at hand. And if the court disagrees with that issue, my point is that I believe that she could have been aware of or apprised of the knowledge of a risk because it was open and obvious. Not that she had advanced knowledge, or not that she had knowledge in advance before she went there, but that at the moment she exited the vehicle, she would have had sufficient knowledge of the risk. But I don't believe that is a dispositive factor in terms of what this court does at this stage. To affirm the summary judgment, this court does not have to conclude that the plaintiff had better knowledge or even equal knowledge of the risk. Those are not fundamental components of whether or not there is a duty that was owed or breached. Here, the question's going back to Judge Jay, to the premise of, was it unreasonably dangerous? And was it open and obvious? And as I've mentioned, this court has held repeatedly that something can be so open and obvious that it makes it not unreasonably dangerous as a matter of law. So if we assume that Panera had better knowledge of this obstacle, and we totally dispense with the trial court's finding that the plaintiff had better knowledge, it doesn't change respectfully where we end up in terms of the questions. Was this an open and obvious hazard? And if it was open and obvious, I believe that in light of precedent, this court can also conclude that there was no unreasonable danger that was posed to the plaintiff. As I've mentioned, I've cited several cases, and just for the record, for the court's consideration, Middleton versus Don Asher. This court held that uneven floor levels are obvious and not inherently dangerous. In Rosenfeld versus Walt Disney World, this court
Let me
held
ask you about that part of your brief, Mr. Ryder. You start that part by saying the courts have affirmed summary judgments in many cases, and then you list a bunch of cases, not one of which did the court affirm a summary judgment, including the Middleton you just talked about. We reversed a summary judgment in that case. Where's the case where we affirmed summary judgment on an issue like this, unreasonably dangerous condition? You say there's a bunch of them, but I can't find one in your brief. You got a couple DB cases.
Well, they might be directed verdict cases, Your Honor, but the directed verdict standard is the same as a summary judgment standard. So again, if I mean, my recollection was that there were multiple cases we've cited that do in fact grant summary judgment for landowners. But if it was a directed verdict, then that was again, the standard is the same. So at the end of the day, it doesn't change the substantive analysis of the application of those cases. But I did believe, Your Honor, that we cited multiple.
Well, the Middleton case you just talked about was a summary judgment case, but we reversed it because even though it was open and obvious, there were still factual issues, right? Unless I'm just
yes, Your Honor.
that case.
No, I of course, Your Honor, I understand, and I certainly want to address that specific question. But as I'd mentioned, and I can go through each one, but in that case, Middleton, it did speak about the fact that there were certain elements of summary judgment in that case, but the court also did find that there was, in that case, let's see. that certain elements, I think, in that case were deemed to be open and obvious, Your Honor. And I think that that's why in that case, we cite that more for the context of something being so open and obvious that it didn't create a risk. But there are multiple other cases where the court have found that as a matter of law, even if they didn't specifically get to the issue of whether or not summary judgment was appropriate in a particular case, they did specifically talk about what does and what does not constitute an unreasonably dangerous condition by virtue of it not being open and obvious. For example, Gorin versus City of St. Augustine, this court concluded that a sidewalk curb uses a platform to pick up and drop off passengers riding a tram is not a hidden dangerous condition, even though others had fallen in the same place. At the end of the day, Your Honors, I do believe that there is significant sufficient case authority to support the conclusion in this case. And I do believe that based on the photos and the de novo review and under the current standard, this was so open and obvious that it makes it not unreasonably dangerous as a matter of law. And we would ask that the court affirm.
Thank you, Mr. Ryder.
Thank you.
Mr. Haskins,
Thank you.
Mike. You've got 5 minutes and 31 seconds, and
Thank you.
Mr. Ryder took about 20 seconds, so I can give you about 6 minutes. So,
Thank you, sir. One of the matters brought up by the appellee in their argument was that, and I want to recite it properly, Bass was not on a walking pathway. She was not walking on an expected pathway. She should have walked directly to Panera. Well, if we look at those, the photo, especially the one we talked about earlier, 142, where it shows the parking stall that her husband would have parked in, and she gets out on the starboard, the right side of the car to get up onto the curb. Her testimony is she turns left, and that's exactly the path that would have taken her to the front door of this Panera. To suggest that she should have walked forward, and that would have been the expected pathway. Well, if you look at this photo, that would put her on the sidewalk, and she could have walked past down the side of Panera to I don't know where, but that is the pathway for somebody intending to get out to go into Panera. The pathway the plaintiff took, and that is to turn to her left. The discussion about trying to equate this condition, this wheel stop, to a curb, or a wheel stop, these are completely different entities with different purposes, with different uses, how they're encountered, when they're encountered. The curbs, the wheel stops are so commonplace, and in this weighted sign base was anything but commonplace without a sign affixed to it. The appellee argued that when it came to the knowledge of Ms. Frazier, that their position is, okay, she didn't have superior knowledge as to the presence of the wheel stop or the base there, since Panera put it there. However, she has superior knowledge as to the dangerousness of the condition and the hazard it posed. Well, this is a case of wanting your cake and eat it too. The argument here is that it is a hazard and it's dangerous and it poses a danger to her. That flies in the face of the other argument that's been raised by the appellee all along that, hey, this wasn't a dangerous condition. Once again, I think this point that this was glaringly open and obvious, I can't think that the facts establish that. I think once again, a jury may take a different position than that. And I'll finish up with my final thought, and happily raise this new summary judgment standard, and that the scintilla of evidence is no longer to way to look at things. And okay, that's fine. And we don't need to look at scintilla of evidence in this case. Once again, I believe that from the case law addressing this new summary judgment standard is whether a reasonable jury could return a verdict for the non-moving party. And I believe, based on the record evidence, that a reasonable jury could, in fact, return a verdict for Ms. Frazier. Thank you.
Thank you, counsel, for your arguments, and we're adjourned. Have a great day.
Thank you.
Thank you.
Thank you. Take care.
Thanks.